Hello, my name's Ken Swinton, and I'm a council member of the Scottish Law Agents Society. This talk is about family gifts in house purchase and should last for around 30 minutes. It's intended principally for conveyancers, but equally it may be of some interest to those who litigate disputed matters of succession, etc. If at the end you wish to have a hard copy of the topic, then this can be found in the September 25 edition of the Scottish Law Gazette. So I thought that this would be a suitable topic for a talk for two reasons. Firstly, the Bank of Mum and Dad seems to be open for a great number of purchasers these days. And secondly, and perhaps more recently, since the budget of October 2024, the plans to include pension scheme values in the estate for inheritance tax purposes may lead to gifts being made by a parent to a child being subject to inheritance tax if the 7-year rule has not been fulfilled. So if we deal first of all with the Bank of Mum and Dad, the idea of parents giving money to children for their house purchase was once comparatively rare. But in research conducted by Savills, the estate agents, in February 2025, they discovered that 52% of first-time purchasers now received support from parents. Now, I don't know how Savills conducted their research, and perhaps their client profile is from slightly higher financial echelons, but nonetheless, we've got that figure of 52%. So more than half of all purchasers rely to some extent on receiving money from a parent. So things that we might want to think about is there any written record of the payment which characterizes it as a gift or characterizes it as a loan? In many cases, it may be that there is no documentation characterizing it as a gift or loan, and it's left as an inchoate problem. The parents, the donor in this case, may have a differing view from the donee, the child, as to whether it's a gift or loan, and that may be something that changes over time. For example, if a payment is made to a son who's buying the property with his fiancée and they subsequently split up, then perhaps the parent would regard it better as a loan rather than a gift. So there are issues there. And similarly, if the parties become estranged, it may colour their views and a parent may demand repayment. There are also other considerations in the event of untimely death of the donor. Executors may seek recovery of payments that are made by way of gift. And similarly, if a party, as the donor, becomes insolvent, then the trustee in sequestration may have designs on the gift as well. So the structure of this talk, I'm going to look at it under these sections. The first of these is sort of property law section, trying to make the distinction between a promise and gift. Then I'm going to look at the presumption against donation. Thirdly, I'll look at presumption in favour of donation in certain situations. Next, I'll look at the UK Finance Scottish Lenders Handbook for the guidance that it provides as to what is required of a conveyancer acting for the purchaser. The general Part A guidance is, of course, supplemented and sometimes contradicted by Part B rules for specific lenders. So I won't say too much about that, but it's something to bear in mind. Then I'll look at terms of engagement, and finally I'll consider some IHT considerations. So that's the basic structure of what I'm going to speak about. So Scots law, as we all know, particularly in relation to property law, is civilian in nature. And we've got words promise and gift. Do they mean the same thing, or do they mean something different? Well, one of our institutional writers, Erskine, at 390, makes a clear distinction between promise, which is a unilateral obligation, and its implementation through donation. Donation is completed by tradition, the handing over of property. That property, if it is heritable property, is the equivalent of tradition, which is the registration of a title. And if the property is incorporeal, movable property, then that will be by intimation of the assignation, as it were, of the donation. So simply making a promise doesn't render the obligation binding. One thing to consider is whether the promise is of a present intention to make a gift, or in fact, whether it is indicative of a future intention to take effect on the death of the donor. And I would refer you to the case of McLaurin against Stafford, 3 Retiat 265. It's worth reading that case to look at that distinction. So promise is in the present, but if the undertaking is to do something in the future on death, then clearly it is testamentary. The promise to be complete requires intimation to the recipient. And here I would refer to the case of Countess of Codder against the Earl of Codder 2007 session cases at page 285. Now, in that case, the Countess of Codder was suing for payments. The alleged promise to pay those sums was recorded in the minutes of a meeting of a family company, but was not intimated to the Countess at the time. And it was held that in the absence of intimation to her, there was no promise which was rendered enforceable. Now, typically, payments by way of family gifts are made with the transfer of funds from a parent's bank account to that of a child without any documentation. So the question of how it is characterized as gift or loan is left open. So could the metadata, the reference in the bank payment, if it's made by faster payment or backed, could that amount to intimation or characterization of the sum that is transferred? So if the reference says gift, or if it says loan, then that would be fairly clear. If it says for house purchase, that remains ambiguous. Now, until someone has looked at that metadata in the transfer by looking at their bank account statement or online, there would be no intimation as to what the nature of the payment was. If a unilateral obligation is made in the course of a business in accordance with requirements of Writing Scotland Act, it must be in writing, but a unilateral obligation other than one given in the course of a business may be oral. So subsequent recollections of a conversation that took place perhaps many years ago, or later revisionist recalling of that conversation to suit later altered circumstances, could be a source of dispute. And again, as I mentioned at the top of this, there may be views taken by a third party after the death of the donor or in the event of their insolvency. So it is certainly useful to get some sort of clarification at the time the payment is made. Now, most students of Scots law will recall from their undergraduate days the presumption against donation. But it's not always the easiest thing to track down in text. For example, there's no reference to it in Logan Henderson, nor is there any reference to it in the late Fiona Wright's books on evidence. So I've taken this statement from Lord President Ingall's opinion in Sharp against Peyton from 1883, Tenretty, at page 1000. And he says that where there has been a transfer of money or other property without any contemporaneous explanatory documentation, there is a strong presumption against donation in such a case, and it requires very strong and unimpeachable evidence to overcome it. So the test is very strong and unimpeachable evidence. In Nisbet against Nisbet's trustees in 1867, Scottish Law Reporter 5 at page 369, the question of a presumption for donation rather than against donation appeared. Now, if you're involved at all with any legal rights calculations, you will be familiar with Nisbet against Nisbet's trustees. It is a leading authority on collation inter liberis, what requires to be collated, and whether a payment that was made to a child was for the purposes of forest familiation, in other words, setting them up in life. In Nisbet's case, the advance was made to a son for the purchase of a commission in the army, which was still taking place in the 1860s. Lord Neaves, giving the judgment of the court, said the presumption that such payments are to be regarded as gifts was of general application, and it was said to be in the context of whether this required to be collated in respect of legitimate claims. The decision in Nisbet was followed in Malcolm against Campbell, 1889, Scottish Law Reporter 27 at page 207. Here the payment was not strictly one that could be collated, because a father made a payment of £89 to his future son-in-law to allow the son-in-law to purchase a business so that he could support the father's daughter once the marriage took place. The wedding went ahead, but subsequently the spouses became estranged, and father-in-law sought repayment of the sum that had been made years earlier. Here it was held that it fell within the principle of a payment made in pietate, made out of a sense of duty. Now, the problem with payments made in pietate is that there's no definition of where the duty lies. And I'll come back and discuss that in a second. But clearly, this was not a legitimate claim case. This was the father suing during his lifetime for repayment of the £89 as a loan. So it looks as though there will have to be, subsequent to that case, further consideration of what in pietate might mean, and that transpires in subsequent situations. In Mailer against Mailer, 2019, Sheriff Court Perth at 101, a payment had been made by a mother to her adult son and his partner. Now, the son had lived for many years in England with his partner. They had a property in England. They decided to move back to Scotland, sold up down south, bought a plot up in the Northwest Highlands with a view to building a new house. Their original building contractor became insolvent partway through the build, and they required to engage new building contractors at significant additional cost. So there can't be any question of the payment being made for the purposes of forest reliation. The son had been major for many years and had made his own way in life in England for many years. So once again, the suggestion was that the payment here was made in pietate. It was a gift, and Sheriff Pino Diomedio opined that the fact that the first named defender was no longer in the first flood of youth would not prevent the case being one in which the mother had acted ex pietate. So the payment was a gift, and it was not something that required to be accounted for in a legal rights claim. In Russell's Executor against Russell's Executor 2025, Sheriff Court Glasgow at 19, a more recent case, the problem arose post-mortem. The deceased in this case was a wealthy accountant who had retired, and he had made payments over the years to one of his sons to bail out that son from a variety of failed financial enterprises. That son, of course, made no legitimate claim, so there was no suggestion of collation. The other brother decided to characterize the payments as loans, repayable when possible. And he was the executor, so he sought repayment of the £70,000 from his brother. If the estate was then divided equally, then it would only be 35,000. Of course, that would be forced to be given back. Sheriff Reid again held that the donation here was made ex pietate, the duty of a parent to support their child being a moral duty, I suppose, because any legal duty to support a child who can look after themselves expires when they become 18. So again, it could be made ex pietate, but once again, we don't know quite what the outer parameters of ex pietate might be. So a parent to a child, a spouse to a spouse, there's no longer any obligation on a child to maintain an indigent or disabled parent. So it looks like it can only apply to parents and spouses. The third recent case that's worthy of consideration is Green Shields against Carey in 2019, Sheriff Court, Livingston, at page 59. The pursuer and defender formed a relationship. At the time the relationship commenced, the defender already had a 6-month-old child who was not that of the pursuer. But nonetheless, the pursuer accepted the child as part of the family and supported that child. In the early stages of their relationship, the pursuer insisted on making payment to the defender of £37,000 to redeem the mortgage over her property, which was subsequently let out, and there was cohabitation in a property provided by the pursuer. Now, the parties here were not spouses, although the pursuer had accepted the child as his. I don't think that enters the equation as part of the decision-making process. So if there's no duty, because they're not spouses or civil partners, then the presumption of donation from a sense of duty, ex pietate, isn't available. But Sheriff Susan Cowan held that the existence of this, what she referred to as somewhat unconventional relationship, was such that it made it easier to overcome the presumption against donation. And Sheriff Craig held that the presumption had therefore been overcome. Whether that is clear and unequivocal evidence is something that has to be considered. It doesn't seem to me be entirely consistent with what Lord President Ingalls had said. Well, let's just try and summarize where we are for the presumptions for and against donation. All three of the cases that I have discussed that are recent took place at first instance in the Sheriff Court, so they're persuasive only and not binding on the Court of Session or the Sheriff Appeal Court. So perhaps the law is not as clear-cut as might at first be thought. I just wanted to mention the Scottish Law Commission report on succession from 2009. This largely restated their report from 1990 on succession, which wasn't implemented at all. The 2009 report largely rehashed the 1990 provisions, but in relation to legal rights, produced two alternative solutions and left the Scottish Government to select which it thought was appropriate. Those solutions were to abolish legal rights as we know it, and the first solution was to allow claims to be made by children who claimed dependency on their parents. So in other words, a needs-based system rather than the rights-based system of legal rights. The second alternative was to replace legal rights with legal share, and that produced fixed legal shares of the estate that would operate in a way akin to legal rights. However, those provisions have been consulted on twice by the Scottish Government and have never been implemented. In fact, there is a recent paper on the Scottish Parliament website reviewing the position, and it appears that the Scottish Government have now decided not to proceed with any reform of legal rights on the basis that while everyone agrees something requires to be done, there's no consensus whether this should be a rights-based system or a needs-based system, and if a rights-based system, how different it should be from the existing legal rights regime. The Law Commission recommended the abolition of collation inter liberis, and therefore the doctrine of foris familiation and the presumption in favour of donation ex pietate in connection with foris familiation. But of course, nothing has been done in that regard. This leaves ex pietate claims now carrying on, and we've seen from the recent case law that they seem to have escaped the constraints of collation and are now more broadly based. But remember that the presumption in favour of donation is a rebuttable presumption, and presumably on evidence shown, the courts will accept that there is no presumption for donation in the particular circumstances of a case. Clearly, it is preferable to set out in writing the terms of a promise and any conditions attached to that promise which must be fulfilled before the gift can be implemented. That is perhaps a counsel of perfection, and in practice, family considerations may be less than solid on this. Brief section is about advising clients on gifted deposits, and the primary consideration here is always identify who the client is. It will be the purchaser, and it's necessary to act in the purchaser's interests. It would be a conflict of interest to act for anyone else in the matter, other than, of course, the lender, for which there is an exemption in terms of the rules. So in preparing any deed constituting a promise to pay, it would have to be the case that this is done on behalf of the donee, not the donor, and that the parent should be advised to obtain separate legal advice. Whether that happens or not, of course, is a quite different matter. It's important to use terms of engagement carefully to avoid mission creep, and it should be clear that no advice is given in relation to gifted deposits in the terms of engagement. However, I would suggest that an information leaflet setting out the pitfalls of gifted deposits could alert parties to necessary issues which might make them take their own legal advice. AML is really the final point that needs to be considered. Anti-money laundering requirements are quite considerable. There's a need to identify the purchasers, the source of funds, and the source of the wealth which generates those funds. Consideration should also be given to politically exposed persons and the sanctions list. Now, how far you go with the parents who are providing the deposit is to some extent a matter for discretion, but I would suggest that it's necessary to get identification for the parents, the source of funds, presumably bank statements, noting the transfer to the purchasers, and to be satisfied on the source of that wealth, which may mean further inquiry. One cardinal rule is never to receive payment direct from the parent, because that would amount to a breach of the accountant's rules. There is no underlying transaction, and it would amount to providing a banking service for the parent, so must be avoided. Lastly, I want to deal with inheritance tax considerations. According to the Savills report, which I mentioned earlier, the average payment from a parent to a child in relation to a deposit is £55,000. Now, that may be Savills clients, and in practice the deposit may be lower, but nonetheless it is a potentially exempt transfer for inheritance tax purposes where it's gifted. If the donor survives 7 years, generally that will fall out with the donor's estate. If not, it will be aggregated along with their estate for the calculation of inheritance tax. And inheritance tax will obviously become a far more significant problem when from 6th of April 27, pension pots are included in the calculation of inheritance tax. Again, I would suggest giving inheritance tax advice is not appropriate at the stage of house purchase, but again, reference to inheritance tax issues and what the issue is might be given in general terms in relation to an advice note that could be passed from child to parent or vice versa. So terms of engagement ought to exclude that completely. It's far less likely that declarations of solvency will cause a problem. If the donor is sequestrated within 2 years, then the gift is challengeable by a trustee, and 5 years where the person is an associate. One favourite tool seems to be a declaration of solvency by the donor, and that's insisted upon by the donee. It is, of course, of limited value should the donor become insolvent. I'm certainly aware of one situation where it was an uncle who gifted, in fact, a building plot to a donee for building a house in consideration of marriage, and he was sequestrated within 2 years, that person not being an associate, and it caused a difficulty for the donor as well as the donee. So finally, advice regarding characterization. I looked at some solicitors' websites, both related to conveyancing and in relation to other matters such as family law matters or private client solicitors. There are examples of websites offering advice. Conveyancers often give advice as to why information is required for AML purposes and exactly what the nature of that is to be given to the solicitors in relation to the deposit. Some solicitors mention a presumption against donation, but on the small sample of the firms that I looked at, I couldn't find any that referred to the presumption within family circles in relation to donation. I've found examples of private client lawyers giving information about the inheritance tax consequences of gifts, and family lawyers offering advice regarding the consequences of gifts. So a more holistic approach might be necessary in some cases. So perhaps awareness documents, leaflets highlighting the issues on which advice might be sought may be the solution to all these problems. I hope you've found this of some interest, and I'll just summarize. Gifted deposits are increasingly common. There may be evidential presumptions. These might be excluded by written documentation. Lender requirements and AML requirements require to be borne in mind by a conveyancing solicitor, and in that regard, terms of engagement to restrict potential liability in relation to IHT or solvency should be written in to prevent any difficulties. But finally, my plea is that clients deserve a broader range of information, and a leaflet setting out all these consequences is, in my view, the best way to proceed. As I said at the beginning, the terms of this talk are set out in writing in an article in the September edition of the Gazette for September 25. So everything I've said is right at the time of recording this, but if you're watching this later, please be aware that there may be changes ahead. Thank you.